Well, hello, hello, hello. Good evening. Can I get a mic check here? I just saw my signal line go in and out, and I want to make sure that I'm not roboting. It's good to see everyone. Hey, Commander. How you doing, Mark? Oh, hi, Mark. Now the Wizero is entered the building. Yeah. Hey, Charlie and Wanda and Sean. Hey, Wrecker. It's good to see you. Thanks for the orders. And Trees, hey, good to see you. Thanks for the audio check. Thanks. Okay, good. Hey, hey, Couch, how you doing? No, no, no mic stuff. Yeah, okay. All right, all right. So we have just a couple more updates. It's been a very, very busy week. Um, as people are coming in. Let's see. We've got the TikTok psychic. That is the Rebecca Scofield in versus Ashley Guillard, the TikTok psychic, um, out of Idaho. We also have Bryan Kohberger out of Idaho. So these are kind of related because they both are cases that stem around the Idaho Fall murders. Although Rebecca Schofield has nothing to do with any of that, except for that Ashley Gilliard seems to think she does. The TikTok psychic who just could not be quiet. I think we'll start with Ashley Gilliard, because since we're already kind of sort of talking about it anyway. Well, basically, Ashley Gilliard, as we talked in the last time, for those of you that aren't familiar, Ashley Gilliard is a TikToker who does tarot card readings and speaks to spirits who tell her things, and she's solving crimes. And she decided to solve the Idaho Fall crime by blaming it on a university professor by the name of Rebecca Schofield, who doesn't know these students, but she said that she had an affair with one of them and she didn't want it. It was an extramarital and same sex affair, and she didn't want to be humiliated. So she organized through someone else to have the murders done. And she said it a lot on her TikTok, like hundreds of times, hundreds of videos, even after receiving a cease and desist, even after the Idaho police came forward and did a press conference and said Rebecca Schofield had nothing to do with it and that those were just rumors and they should stop. Like, no. Well, she kept going. She also decided to represent herself. And the judge in this case, it's a civil suit, okay, for defamation and for punitive damages, for actually hurting Rebecca Schofield's reputation at the college, making it difficult for her in the area. Um, as you can imagine, it was not very pleasant for her to be associated with such a horrific crime, especially in such a negative way, as if she had anything to do with it or anything to do with the students. It was terrible. The whole area was in an uproar at the time. But Ashley Guilford, she just thought she knew. Her spirits were telling her that this woman did it. And she says it's a tarot card reading and she stands behind it. And just because the judge in law doesn't actually understand these things doesn't mean that, you know, Rebecca Schofield didn't do it or that she's lying. Well, I'm afraid the law kind of goes against her there. Well, she did decide to represent herself, which probably wasn't the best move because even though the judge was being quite lenient because she was representing herself, she ran into some problems with discovery and filling out the interlocularities, the questionnaires back and forth from the attorneys. She ran into some timing issues during October, November, and December. And actually, Rebecca Schofield was going forward because she missed the deadlines to say that she should get a partial summary judgment. But the judge kind of held off and gave gave Ashley Gilbert more time to answer the questions and get, discovery done, and put a deadline of the middle of December for the rest of discovery. I think he gave her like another 4 weeks or something like that, to get it done. And she did get part of it done. She answered a few of the questions, but not the rest of discovery. And so discovery is closed. And that's a problem for Ashley Guillard, because in answering all of the questions that she did, most of the time she said she was just doing a tarot card reading, or that the evidence of the case would soon be disclosed, and that, she would present the evidence. Although she's missing the point that discovery is closed. She doesn't have an opportunity to do that anymore. She's well past the date. She says that the actual investigation is what's going to prove that Rebecca Scofield actually did this, in that she can't be held to actually prove that. It's up to others to prove it. She just knows what she knows, and that she should be able to say it, because you can't prove it's not true. Although they can, because she's not part of the investigation. And apparently, Ashley Gilead doesn't get the fact that she's the one that has to prove what she said was true for it not to be defamation. She has to prove that her statement was not done without intent or maliciously, and she has to actually prove that it's true if she doesn't want to have defamation. And unfortunately, she can't, although she thinks she can just by saying that it was a tarot card reading, and that, the spirits don't give you truth. They don't give you proof, rather. They just tell you the truth, and you go with it. And just because the court doesn't believe in it, she felt that was a valid reason for what she said and did and continues to do, Oh, okay. That's a very good question, Mark. Hold on. Let me pull that up. Let me get that up here. So if discovery is closed, but some new evidence is unearthed, how does either the prosecution or defense enter it into trial? They do by actually bringing it up by a person of interest, either on the witness stand or not, or actually filing a motion, a sidebar, where they could both agree to bring it in if it's of benefit. Happens all the time in trial. It can be done during the trial, but not pre-trial like this, like after discovery is closed. It would have to wait until then, as far as I know. But that happens all the time with things that come forward. And then whether it's relevant or not, or one side or the other can try to keep it out based on the timing and all of it. But if it's relevant, the judge will usually allow it in. There's a protocol. It's usually during the questioning and answering of a witness of some type. We just had that in the Trump in the Trump Carroll case today. Alina Habba, Trump's attorney, tried to enter in a tweet or a book or something that was not in evidence yet, and the judge was trying to remind her on how to do it. Like, you have to do it question and answer, and then you have to say, I'd like to enter this into evidence, and that there's no objection, and the judge goes yes, and it gets a number on it and all of that. Well, she couldn't remember. She just wanted to show the person the tweet without it being entered into evidence. Like, she just thought if she showed it to her, it would work. But she got schooled. Hello, Liam. Free the banner. Oh, goodness. Oh, I forgot again. Yes. Okay. There we go. That's a good way to get me to remember. Okay. Hello, Mrs. Cassandra. All right. So anyway, she did not make it through all the way through discovery, and because she didn't finish the rest of the questionnaires nor complete the the discovery information, now Rebecca Rebecca Scofield has come forward and she has actually filed for partial summary judgment now. She did that on the 12th of January. She waited a good month till discovery was closed, after, and everything went through. And basically, what she's saying is that since, the legal standard is that since, Miss Gilliard's responses to requests for admission do not raise a genuine dispute of material fact. And that is because in almost all of the questions, she said, yes, she did say what she said, and that she did it because it was a tarot reading. I mean, she answered it. She did not deny any of the statements. She did not have any defense for anything that she said. She was admitting repeatedly that she did say what she said, and yet could not prove substantially anywhere that her statements were true so that it wouldn't be defamation. Okay. Um, it is a matter of law, like, uh, at this point, that summary judgment, since Miss Guillard has failed to actually come forward with any type of defense in regards to the statements, and actually has to admit that most of those statements that she made, the videos she made, and she continues to make to this day. I mean, to just the other day, did another, you know. She has no evidence for the facts showing for any statement that she has made against Professor Scofield, involved in this, and that she was involved in the Idaho 4 murders at all, or associated in any way with students, whether in a curricular way within the school or outside of the school, in private dealings that she is claiming that were done. She has no evidence of facts. She has not even claimed to have any evidence of facts anywhere that she had an affair with the student KG. Um, these were like horrible claims that she was making, Ashley Guilford made against Rebecca Schofield. And anyway, the facts of law say that she did not actually come forward. Her own answer to the questions in the interrogatories were actually confirmed that she did everything she's being accused of in the lawsuit. The facts conclusively established by Miss Gilliard's admission alone, the TikTok she posted, and Professor Scofield's declaration demonstrate Professor Scofield's entitlement to judgment as a matter of law, summary judgment, meaning the only thing they have to go to trial for is the amount that will be paid. That we are going to actually she is asking the judge to put on record that Ashley Guilford the statements that she made were defamatory. Okay. The reason that she's going for punitive damages is that the second part of the allegation against Ashley Guillard was in the claims that she made that there was a sexual misconduct with students and Professor Scofield, that was actually damaging to her career and was stated to cause great harm. And so she wants punitive damages too, because of what that could have done to her reputation and how egregious a statement that was, to be made. It was to cause damage. It was a false statement. There's actually no truth to it. Again, in their own things, she has absolutely nothing about it, just that her spirits told her, you know. And unfortunately, that's not a defense. And that is why, for all of these reasons, Rebecca Scofield has asked Professor Scofield respectfully requests the court grant her motion for partial summary judgment and hold Miss Guillard liable for her defamatory statements as a matter of law. The evidence conclusively establishes that Miss Gilliard's statements defamed Professor Scofield. All that remains is for a jury to determine the amount of Professor Scofield's damages. And that is our update. Now, of course, to date, there's been no answer on Guillard's part, but I don't really expect there'll be much. We should wait for the court to either deny, put it through, or deny. I don't see why they can't. It is a matter of law. They've already given Ashley Guillard several extensions into actually to comply with actually finishing discovery and answering all the questions back and forth. Um, so we will see. Mhm. I would love to see Mousy. Hello, Mousy. I would love to see if she can subpoena the spirits. Exactly. I mean, then I not to make light of it. I know some people like believe in all of that, and you know, and I'm not like gonna weigh in either way on it. I'm just gonna say, like, if you can't actually present it in court, I don't really think she should be talking about it that much. Like if they're not able to come to court and help her out. Yeah. I wonder if she will backtrack by saying it must have been Satan pretending to be one of her spirits. I don't know. I don't know, but like I was joking before, saying, I don't think they're leading her the right way or whatever. But like, in a court of law, it really kind of matters that you have stuff to back up what she's saying, and she doesn't. Her only answer was that it was a tarot reading and that it was being told to her through the spirits that way. And that for her, that was all that she needed. Mm. Listen, subpoena is a hard word to spell, but look at you all. You all can. I'm proud of you. Anyway, okay, so that's the juice on. If you guys don't have any questions about our TikTok psychic friend, that's basically where we are now. We're just going to wait for the judge to see if he's going to approve or deny, the motion for summary judgment. I do think, based on what's going on, that it leans more towards applicable law to allow it. In that way, when the trial does come forward, the civil trial comes forward, or they will just have to decide, the jury will just have to decide on the amount that would be awarded to Rebecca Scofield. And that's done in advance to save a lot of time, save the length of trial and all of that. And just to because when it's a matter of law like that and it's already happened, it seems redundant to go through the process already. I mean, the same thing happened in Eugene Carroll's case for the second lawsuit, is because there was judgment already on the exact same claims. They were allowed to go through with summary judgment that fact of defamation has actually exists already. And now you just have to tell us how much it's worth. How much damage was done to the reputation? How much are we going to even it out with the civil payment there? You know. Hey, Tsunami, welcome. Yeah. We're just gonna I'm gonna move on to Bryan Kohberger now. Yeah, the Bryan Kohberger case for the Idaho fall murders. We have only a few updates. The first one being that although the judge denied the motion to dismiss in both areas, in both cases that were filed for Bryan Kohberger, that was all done under seal. Bryan Kohberger and his attorneys have now filed forward that they would like it unsealed, the motion to dismiss, because they want the public to read all of the reasons that they want that out there now. Now they are saying they want a lot of this stuff unsealed. Oh, thank you, Mark. That's very nice of you. Thank you very much. Thank you very much for. I will be putting this toward the beast of a computer that's being built right now. Thanks for providing a quality channel. I appreciate that, Mark. Thank you so much. Thank you for being a quality person who views my channel, a subscriber, and a chatter, a live chatter, in somebody who's enjoying the true crime. What kind of quality? A beast of a computer, meaning it's big and tough. Yeah. Uh, Liam, really? What kind of quality? Wait, like, really? Is that mod behavior? You're supposed to support us. Stop it. Be good. Anyway, back to Kohberger. So, in his attorneys, who now want us all to be able to read all of the motion to dismiss uh, areas, and they want it all public now, and they want a lot of stuff like unsealed now. Okay, so in regards to that, that's like a public relations move, because if you'll remember, the defense has wanted everything like clamped down really, really tight. This is a move in a different direction for the Kohberger team. I mean, they have not wanted anything out in the public, and now they want things unsealed. And it's just quite curious. I mean, what do you guys think? I mean, that's a little curious to me all of a sudden. Although remember, like the judge did them credit as some of their arguments were quite entertaining, even if there was no law to back them up. And I wonder if they just want to, get this out there to try to just change a few minds about things. I'm not sure. But either way, it could affect the jury pool, I guess. But I don't know how detrimental it would be. It is just a motion, and it was denied. Like, and they're not going to dismiss the case. The other thing I have is that the prosecution came forward with a motion towards the end of December, the beginning of January, asking for the trial date to be scheduled. And what was interesting about that filing is that they asked for a specific period of time. They would like the trial to be in the summer of this year, in 2024, when the university and the high school is not in session. For the high school reason is because of the parking all over and around where the courthouse is. And so they're asking that the trial be held during the summer, because with the school not being in, there'd be a lot more parking, and everything available. Also, without the college being in session, there would be a lot more travel accommodations in rooms, hotels, and everything, and less in the businesses in the area for those that are attending the trial. It would be more convenient. Yeah. Mm. Hey, Fishner. You know what? It's I just like I'm glad to hear that they're moving towards summer. Right now, because that means like this year in 2024. Remember, they have not taken the death penalty off of the case here for Bryan Kohberger. I mean, they haven't said they're going to definitely pursue it, but it's not off the table either. Like, so he's also gone, like he's also taken the option not to go for a speedy trial when he started to do his motions to dismiss, and didn't put his plea in right away, remember? And he's going through discovery and all now, so mm, I don't know. August sounds, summer sounds good. Like July, August of this year. It's not so bad. It's not that far away for a trial. So I thought that was interesting. There was no objection by the defense yet that I saw on file. Well, like I said, the prosecution put this motion to get all the dates in order for discovery, pretrial summaries, all of that, all of the dates that are necessary before trial too, so that they knew what they were preparing for. So they put that motion forward. There's been no answer on either side yet. Um, well, the last thing that I have is in regards to the DNA. Do you remember that our judge was going to look at all of the DNA evidence, because there was much going back and forth in regards to the way that they were led to find the suspect, Bryan Kohberger, to actually say that he was the one. Okay. Because they did not get a direct hit in the beginning. If you remember, it was familiar. Okay. So there's a lot of back and forth with the defense demanding the DNA processing, the DNA evidence, and because they had used IgG. IgG DNA testing, and IgG stands for Investigative Genetic Genealogy. it is used a lot. Okay. It is when, after they have put DNA through the normal investigative techniques, which would get them into the regular computer systems for law enforcement, like codex and all, for offenders. Remember, you got to be in there for a reason. You had to have a serious background check, or you had to have a violation of some type. Okay, not everybody's in there. The world is not in there. Okay, where most of us are these days are on sites like, 23andMe, and, Ancestry.com, and things like that. That there's a whole network of genetic material online with individual profiles. And it has become quite common for everybody to use them. That after going through the regular means to get into a narrow the suspect pool, they'll start doing comparisons with these genealogy sites. Okay, when you actually submit your DNA to these sites, you put a waiver in there. There's nothing illegal about what's going on here, and there's no violation of privacy that's going on here. Okay, because even in a court of law, the reason the defense team could not automatically get the IgG material is because family tree names were on there. And that needs to be redacted. They wanted to make sure that people that didn't necessarily need to be exposed in a court of law were exposed in a court of law. Because once they enter it into evidence this way, they don't want everything exposed and out there. So it's on a need to know, which is why prosecution was holding it back from defense, because they just needed to know the process and they needed to know how it handled, but they didn't need to see all the reports with all the hundreds of names and all this other stuff on. Okay, but what they're trying to prove is that there was no link. But it's going to be pretty hard because there was a direct link from the father to Bryan. Okay. Now, they're going to have better luck trying to get the DNA itself thrown out from the sheath. That could be contact. We all know that it wasn't a lot. It's already said so. That could be on that knife sheath just because he touched it in a store. Okay, before somebody else bought it. It doesn't necessarily mean it belongs to him. We're talking about touch DNA that can be put on something in very many different ways. It doesn't mean he had to commit the crime. It's going to be interesting. I mean, I want to see the rest of the evidence that they have on Bryan Kohberger when we go to trial, because they're pretty adamant that he is definitely the one, but the stuff that has come out, like, that just doesn't seem to be a lot. There just doesn't seem to be a lot to tie him to everything. And I don't blame the defense for trying to get the DNA tossed out, because just the words DNA are pretty damning. Okay. And it makes him look guilty if anything that belonged to him was anywhere near the crime scene. Of course they're going to try to get it out. Okay, but I don't know if they're going to be able to get it out by going after the IgG technology. I really don't. I mean, to me, that just doesn't link. It just doesn't make a lot of sense. For those of you that like the sciencey stuff, I've got misconceptions in regards to IgG. Some of the most common rumors out there about how it gets used. Okay, and also there's, of course, there's the regular wiki, which is just going to give you, some basics to go by. But the interesting thing is they always list some references to take your research further, which is pretty good. Okay, but when you do read up on it, you're going to find that IgG it's not that new. Okay, and it has been used for a while. The FBI uses it, in federal investigations. It's being used a lot. Okay, and it's really not that sophisticated because the databases, I mean, it gets complicated when you want to use it for evidence, because everything has to be traced on, how everything gets entered and where it leads to. But they're not going to be able to get past the fact that a swab of Bryan Kohberger was taken itself and compared to the touch DNA, and that is where the big match is. They may have been led to Bryan Kohberger by a family genealogy tree, but that is not that odd. They didn't arrest anybody else in the family. They were able to narrow it down, and they had more than that when they went. Okay, they had the vehicle. They had some cell tower pinging. You know, they had more. You know, so I don't know if they're going to be. I don't think they're trying to prove that in the process of getting to Bryan Kohberger as a suspect, that there was overreach or there was some kind of mishandling done on or you know misappropriate or misappropriation of evidence or utterly just things that shouldn't have been done the way that they were done, which you know a defense is required to do the best that they can to get everything tossed out that they can, so the case is not as much because they believe their client and they're going to want to get a non-guilty. But we got to see on that. I don't know. It was very interesting though for me. Investigative genetic genealogy, used to only hear about it on like the big fancy shows on TV and stuff like that. It was always like something you didn't happen, but from what I'm reading, it's happening every day and it's being used every day and more, and it does narrow the actual prospective suspect pool down greatly, and so it's quite beneficial. It's quite beneficial. But there are some legalities in regards to how you protect all the names on those trees. The innocent people that don't deserve to be tied into court cases where they don't belong. Like, how do you keep all of that out? And that's what's going to be the legal wrestling that's going to be going on in the courtroom in regards now. Now, Judge looked at it all. He did redact some of the information. He did not. He said that they didn't have to turn over everything, but he did put out an order on specific things that they did have to turn over to the defense is in regards to the evidence, the IgG DNA evidence and reporting. Okay, so he did as he said he would. Remember a month or so ago, Judge said, "Give me all that DNA stuff. I'll try to go through it the best I can, and we'll come up with something," because of the back and forth in regards to why the prosecution did not want to release the information and why the defense thought it was so necessary. I mean, they're allowed to challenge how you get to the conclusions that you get to. That's part of the defense. Okay. It's part of what they do, so they say that they need that evidence to do that. And the prosecution didn't want to give it to them because they don't need the whole family tree line and all of that, how that happened. Oh, they don't. And that was too risky to expose everybody else. It would be a violation of their privacy. So there we go with that. Well, that is all I have for tonight. That was it. Just two brief updates. I didn't want to make it too long. 20 months has gone by. Wow, that's fast. I miss game night. We all miss game nights. It's been a rough winter. It really has. Hey, Pete. This is Moscow, Idaho, a small city where hardly any homicides happen. 4 of us. Yep. How do we think that is the last 13 months? No one else was suspected. They have BK. Exactly. They have him. But do they have enough, right, Pete? This is what I wonder, Do they actually have enough? I feel like it can be explained pretty easily without getting too deep into genetics. If they have an expert that is efficient at simplifying it. Exactly. It's going to be one expert against the other expert. You're going to see what the percentages are there. I mean, a lot of times it is hard to argue the numbers. Once they say it's like 1 in 9 million trillion, whatever, it's kind of hard to say it would be somebody else. Yeah. But that only matches the DNA to that sheath. In its touch DNA, it's very little. It's from what we know that's available of the DNA. Like, I have to keep saying that because we don't know everything that they have. The case got slammed down so well. We know the stuff's going back and forth. We know there hasn't been much of a leak on anything else. And that we know that, there possibly there could have been if anything else was there, but we don't know what the case is like at all yet. We just know the little bits from the beginning. We don't know what they've actually found, what the investigation actually completed. But they seem to be pretty sure that they have their man, so I feel like if someone had their DNA on a website like Ancestry or 23, they're already given permission for yes, it's part of the agreement. It is, yeah. There's no violation of privacy there. What they're trying to do is not get them to be part of these laws, like part of these cases, as documented evidence, like all over the place, because the information on these reports gives more than just their name. Okay, it gives percentages of this, that, and the other thing, um and so some of it is just personal information. Exactly, Tsunami. Tsunami. If you keep it private, you can't share the DNA profiles with other. And the whole purpose of being on the site is to share the DNA profile so that you meet the rest of your family or you find the rest of your family trees and etc. So it's kind of open ended. Yeah. In my opinion, once your DNA is out there, the authorities have access to it, whether or not they have permission. This is true. I mean, it's everywhere, correct? I mean, I do think somewhat similar there, Mark. Um, we just gotta wait till he falls. He knew Idaho has the death penalty. Why he chose Idaho? He's never going to be caught. He thought he wouldn't get caught. Yes, it that theory that this is part of him planning out the perfect crime. With his fascination and everything like that. I have heard all on that. But yeah, death penalty has. Idaho still has the death penalty, and he's up for it. The smartest person in the room, exactly. Like a lot of these crazy killers, they think so. You know thinking he's never going to be caught. Mm. Well, that might be why there's not a lot of other evidence that we have heard about. Maybe they're keeping it really tight-lipped, which I hope so. Yeah. But this crime was very messy and far from perfect. Although, if he did do it and there was no blood in his car, his clothing, his apartment, anywhere, mm, it is hard to fathom how somebody can get it out there with none of that anywhere. That would be pretty perfect. Mm, mm. Anyway, on that, I'm gonna keep it up. I will see you guys on Sunday. I don't know if I'm going to be streaming tomorrow. Every day I have been trying to get a little bit stronger with my voice, to get a little bit better. But it uh it just keeps going out on me here and there, and you can hear that it's getting a little shy. King Von, though, oh, record, yes, this is a rapper that I just learned about that talked about all these murders that he did in all his songs, and nobody was like believing he actually did it, but he probably was a serial killer responsible for those crimes. Yep, yeah, it was fascinating. I'm getting into the cross off between rap in lately and murder. Thank you so much for the sticker, Mousy. I appreciate it. It's cool. Thanks. Anyway, there's no way that killer didn't take evidence back with him. Exactly. He had to, right? He had to. Liam. Thank you very much for the well wishes, guys. My horse impersonations are getting worse. Yes, they are. Thank you, Mrs. Cassandra. Thank you. Okay, guys, I will. If I'm not back tomorrow, I will be back Sunday. Okay, have a good night. And if you think of any other questions in regards to the TikTok psychic and or Bryan Kohberger, just put them on the back of the video. I promise to answer everything. Okay, on that, I'm going to say good night. Good night, everybody.